Welcome, everybody. We're going to give it just a minute here for more people to jump in before we get started. So grab a coffee, get comfy, settle in. We think it's going to be a really helpful, maybe even entertaining session. For those of you who don't know me, I'm Kim. I'm the Director of Account Management here at HR Covered. I'm absolutely thrilled to be joined by someone who probably doesn't need an introduction, but I'm going to go ahead and hype him up anyways. He is the best of the best, Canada's very own HR guru, our VP of HR Services, Darcy. We love our clients. Great to see you here. I always like looking at the list of everybody coming in ahead of time. I see a lot of familiar names. For those of you joining us for the first time, just a quick introduction to HR Covered. We help businesses of all shapes and sizes, all the way across Canada, for all of the things that matter the most. So things like saving you money, minimizing risk, maximizing employee engagement, and of course, keeping you out of legal trouble. So today's topic, I know, is a very timely one, probably for most of you here. We're going to be talking about seasonal workers. Hiring them, sometimes I know I've been told it's like speed dating. You've got quick decisions, fast training. Sometimes you're just hoping and praying for the best. But don't worry, Darcy's going to walk us through how to find them, train them, navigate all of those rules, and keep the best of the best seasonal team that you've ever had without losing your sanity or your budget. A few quick housekeeping notes before we start. This session, of course, is being recorded. We are going to send it to you afterwards. You can rewatch it as many times as you like. You can share it with anyone that you think will find it helpful as well. The format is going to be Darcy's presentation, followed by questions and answers. So please feel free to drop your questions in the chat as we go. We are not going to be touching today on immigrated workers, agriculture, sector-specific type workers, but we are going to be going through everything to do with seasonal workers that we possibly can in this time. Most importantly, this is a safe space. We're here to learn. There are no bad questions. Maybe there's some bad jokes. I don't know. You tell me. But let's have some fun with it. All right. That's enough from me. Take it away, Darcy.
Thanks, Kim, and thanks, Sony, behind the curtain there. That's Sony's our marketing specialist who makes all this happen for us. So, and Kim, thank you so much for being part of these webinars. It's been great since you joined. It's awesome to have you as a co-facilitator, and you bring so much wealth and knowledge to it, especially when I'm finishing up. That it's great to have your experience here. So everyone appreciates it. I'm positive. So hey, so yeah, we're gonna jump in. It's a loaded topic, just because with seasonal workers, it's so specific to obviously the industry, and then as well as the just waiting for that to go away, and that will go away, and then this will come back. And sorry, I'm talking through my IT head here. But there's so many industries that are seasonal, but on top of that, every jurisdiction for seasonal workers is a little bit different. So that's why when Kim said we're veering away from industry specific questions, we're going to speak more in generality. That's the case. I know that we have a lot of our partners here from the NGCOA. Welcome. Thank you for being our partners. It's a great partnership that we have with the National Golf Course Association of Canada. And I know I said that a little bit wrong, but it's just why I speak. Yeah, so there's a little bit there that we could speak to as far as golf courses specific as well that we'll touch on. But we're going to jump right in because we don't have a lot of time and we have a lot of content to cover, and we want to make sure that we get those time for you to have questions in the Q&A. Make sure that if you have questions, as Kim said, send them in now. We had a whole bunch of questions that were asked in advance, so we want to try and get to them as many as possible. So seasonal employees, things that you need to know. So seasonal employees, and this is actually a little bit of a misnomer from clients that I've met over the decades, but seasonal employees in fact have the same rights as permanent employees for the most part. So there's always, like, when I say same rights, basically when you look at the ESA or the ESC respectively, they have almost all the same rights, core basic rights, that any other employee would have, whether they be part-time, permanent, special, et cetera, et cetera. There's always going to be exceptions to the rules with seasonal employees, and it varies from one jurisdiction to, like, for example, if you're looking at fishery or agriculture or something of that nature, there's so many exceptions. The list of exceptions is harsh. Something that's more identifiable for a lot of our golf course owners here today, when you look at landscape gardeners, which doesn't cover all golf courses in every jurisdiction, but certainly in most jurisdictions, including Ontario, for example, there's exceptions to the rules around overtime, hours of work, and whether they get paid on a statutory holiday. In other words, you can bring them in for the statutory holiday. You don't have to pay them statutory holiday pay. You can work them more than 44 hours or 40 hours a week, respectively. You don't have to pay them that. But as far as like minimum wage, work off between shifts, things of that nature, it's the same as a permanent employee, and that's important to note. Requirements different. There we go. I got ahead of myself again. Requirements different between jurisdictions and industries, obviously. And this is a great example. Seasonal workers in the hospitality and restaurants can be required to work on a statutory holiday. Retail workers can refuse. So like there's a big difference between there. And like, I have a little picture of a Christmas tree, because even though we think of seasonal workers in like a golf course, fisheries, agriculture, forestry, what have you, seasonal work can also be season specific. So example, you'll have a lot of students that get hired during the Christmas season. So during the Christmas season, you have to be mindful that and we might do this webinar again during the Christmas season, because there are so many workers that get hired then, but certainly this is appropriate for the summer workforce that's going to be coming into play in the next little bit. Seasonal workers are required. This is an important slide. Seasonal workers are required to have the same training, including health and safety, as permanent employees. We have this question, unfortunately, and I know most of the time it's simply because you don't know. Some of the time, and this is unfortunate, it's simply because they know and they would like to find a way around it. But your seasonal workers are required to have all of the training that any permanent worker would have. And oftentimes, depending on the way your contract is set up or the nature of your contract, which we'll get in later, they have to have it year after year after year. So it's not simply a case where with a permanent employee, you could give them, for example, workplace harassment and workplace violence and harassment training, give that to them and when they first start, and then you wouldn't have to give it to them again for 2 to 3 years. With seasonal workers, depending again on how the contract is set up, you would have to give it to them every year they start. So we'll get into that a little bit later in the presentation. The employment agreements. Employment agreements for seasonal employees are typically fixed-term contracts. Ironically enough, as people wake up to the difference between a permanent contract and a fixed-term contract, a lot of seasonal employers are starting to use permanent contracts instead of fixed-term contracts. Again, we'll get into it, but it's critical, and this is why a lot of people are moving to the permanent contract. If you're going to have a fixed term contract, it's critically important that it's developed properly, that you understand why it's done a certain way so you can execute it a certain way. Because if it's not developed properly, you're going to have liability. Even if it's developed properly, if you don't execute it properly, you could have significant liability. So with permanent contracts, you don't have that. You just don't have that. You hire somebody, the worst case scenario, if you get hung up, you did a layoff that you were supposed to do, you let a layoff go along too long, you terminated somebody, what have you. The worst that could happen to you is you'd have to pay common law, right? Whereas with fixed term contracts, the worst that could happen to you is you might have to pay 6-12 months pay. So, there's a lot of benefits to fixed term contracts. There's inherently more liability. And again, we'll discuss that in the upcoming slides. In many jurisdictions, the ESA or the ESC provides for assumed right for the employer to lay off the employee for specific industries. So what I mean by that is in specific industries, namely those industries we don't want to talk about right now, agriculture, construction to a lesser extent, certainly fishery and forestry. If you get laid off in those industries, you don't have to have something in your employment agreement. You just don't. But because the ESC or the EAC says it should be assumed that that's a condition of employment when you first started. Not in all industries. And golf courses is one of those industries for the most part across Canada where it's not assumed that you're going to be laid off, which is why it's essential that you have the right to lay off in your employment agreement. Even if it is assumed, why would you take that chance? It's 2 lines in your employment agreement basically. So, and in certain cases you can make it 1 line, but it's maximum of 2 lines in your, if I froze, I could see myself freezing anyways. Fixed term contracts, even for seasonal workers, even when ended properly, may result in common law consideration at termination. So we're going to talk about this. You can see here on the right side of the screen, the last 3 points, it speaks quite a bit to fixed term contracts. When we did the marketing, or at least I did on my LinkedIn page for this webinar, I did encourage people that necessarily didn't hire seasonal workers, but used fixed term contracts to, please attend, because the fixed term contracts seem to be, when we get our questions from our seasonal employers, 90% of our questions are about the fixed term contracts. That is what seems to, quite frankly, that's where the liability is, but it also seems to be where the uncertainty is. And whenever you have uncertainty, that creates liability. So we want to try and fix that for you today. Fixed term contracts. There you go. So we're going to talk about that right out of the gate. Fixed term, actually, yeah. Oh, sorry, did that quick. Happy finger. Caution when hiring. So often seasonal employees have physical demanding jobs. This is a big deal, and we're seeing more of this and more of this lately, simply because people nowadays are well more aware of their rights. And if you've attended any of my webinars in the past, you know that I've said this to you, that doing this almost 30 years, the difference between now and 10 years ago is astronomical about the amount of knowledge employees, even younger employees, especially younger employees, matter of fact, have about what they're entitled to, what they could get, whether it be through the right way or through kind of a scammy kind of way. But employees know a lot more about their rights. So we're seeing a lot more of these human rights claims when somebody puts in that you have to do heavy lifting more appropriate for a man or anything of that nature in the hiring process. You have to be careful not to ask questions that lead to discrimination. So you have to be vague that heavy lifting is a core requirement of the job and leave it at that. Then once you get into the interview process, say, are you able to lift heavy objects? You don't, but the way you post your jobs, the questions you ask are super important because it could lead you down a bad path. So set expectations. So it's really like we were just talking about landscape gardeners as one of the exceptions, and that includes like people that take care of golf course greens. So, you have to set expectations in your employment agreement. It's super important. I'm going to use the golf course example again here because I know that a lot of you are here. We're excited about this webinar. When it says, like for golf courses, for example, when it says that you do not have to pay holiday pay for golfers working or for employees that are working on a statutory holiday, that is true. If you don't have it in your employment agreement that they must work the statutory holiday as a condition of employment, then they can refuse. That is their right. So it's really super important that when you have these seasonal contracts, that you make sure that, if attendance is a requirement of employment, you're going to ask. And I had a great conversation with the golf course owner yesterday, and I put some of her questions in here. I told her I wouldn't name the name of the course. She said it was fine, but I'm respecting her privacy. She's either on here or going to watch this. But she was going on about, attendance and things of that nature. And it's like, if one of your core expectations of conditions of employment is attendance, that at the beginning of the year, we're going to ask you when you're available and when you're not available. And based on that, we're going to give you an employment contract. Make sure that's in writing. Right? Make sure that's in writing. So when they come to you and say, hey, by the way, my mom and my parents want to take us on a trip to Cuba or wherever, I need a week off, and you say no, and they decide to go on that trip, you could terminate them with cause. If you don't have it in writing in your employment contract, you can't. You can terminate them, but you're going to have to pay them, right? So that's super important that you set expectations and make sure it's in writing in your contract. End date. So the very first time I spoke at the NGCO conference, which was awesome. The people were amazing. The very first time, and I brought this up, and like half the people in the audience were like, "You got to be kidding me!" And it's like the definition of a fixed term contract means it must have a start date and an end date. Period. If it doesn't have an end date, it's not a fixed term contract. When the season ends, at the end of the holiday season, at the end of the construction project, those are not end dates. Those are terminology about when something may happen, which no one knows when it is. That makes it a permanent contract out of the gate. You could still give notice. There's still ways to mitigate your liability there and make sure that you don't have to pay, obtrusive amounts of, all this types of different things. But an end date requires an actual physical date. This is the date this contract ends. If you don't have it, it's not a permanent contract. You have to provide working notice or pay in lieu of notice before the season ends. With the idea of a fixed term contract with an end date is you don't have to do that. That the end date is inherent, or the working notice is inherent in the contract. In other words, if you're going to give somebody a 4-month contract and it has an end date on it, then you're giving them 4 months of working notice. If you give somebody approximately a 4-month contract, knowing that the season will end in approximately 4 months, you're not giving them a fixed term contract. You don't know if the season's going to end in 4 months. So you would have to give them working notice or pay in lieu of notice to make that happen, right? And that could carry with it common law. So it's really important that you put an end date in your contract, even if that end date may move. And we'll talk about how you can cover yourself or protect yourself from that. Termination clause. Here's the things you need to know. This is the most important thing. We were talking about the difference between a permanent contract and a fixed term contract. If you terminate somebody in a permanent contract at any point, after you hire them, it's an indefinite term, right? So if you terminate them at any point during a permanent contract, you either pay them what's owed by the termination clause, or worst case scenario, you don't have one in there or it's unenforceable, you pay them common law. worst that can happen, right? If you terminate somebody in a fixed term contract and you do it early, then if you don't have a termination clause, you owe them the entire duration of that contract. So if you brought somebody on board for a year, for example, and after 3 months, you decided, this isn't working out, or after 4 months, just so we don't get into the probation thing. After 4 months, you decide this isn't working out and you let them go, you owe them 8 months of employment. Right? That doesn't happen with a permanent contract. If that was a permanent contract, you owe them a couple of weeks. But in a fixed term contract, if you end it early, you owe them the duration of that employment agreement. Even if you have a termination clause, you have to make sure it's enforceable. And I can tell you right now, and I've done multiple speaking presentations for the NGCOA, as well as chambers and other, places where we've had this conversations, that if you haven't had your employment contract reviewed in the last year to two, your termination clause is likely not enforceable in most jurisdictions. So it's really important that you have your employment agreement reviewed on the annually. Kim and her awesome team is great about reaching out and making sure that we offer that to you. And if you don't have employment agreements, we'll make sure you get them. And if you're not a client, why aren't you? Because, anyways, that's not my job. So, but yeah. So, and then layoff clause. We've already talked about this a little bit. In some jurisdictions and in some industries, layoffs in seasonal industries can be assumed. So you don't necessarily have to have it in your employment agreement. In Quebec, it's the one jurisdiction in Canada where you're not required to have a layoff clause. You can actually lay off, and the rules in their legislation allow you to do that and governs the process. But in every other jurisdiction across Canada, assuming it's not assumed in certain seasonal industries, you have to have a layoff clause. And again, even if it's assumed, why wouldn't you? It's a sentence. Right? Why wouldn't you protect yourself saying we have the right to lay you off as operationally required? Done. Right? So make sure you have that in there. The termination clause, the layoff clause, and the end date, got to have them. Expectations, really important operationally. It's not going to be the make or break for you, but it will tie your hands. And again, caution when hiring. Okay, just make sure that you're mindful of human rights, and that if you have any questions about that, by the way, don't hesitate to call us. We have people call us all the time and ask us. These are interview questions we want to ask, and it involves things about heavy lifting or being able to stand for long periods of time. Are we okay here? We're happy to answer those questions for you. That's what we do. What I don't do is know how to use technology, apparently. There we go. So ending a fixed term contract. So as much as having a fixed term contract and knowing what should be in it is one thing, the ending the fixed term contract is where the liability comes into play. If you don't have a properly done contract, like none of this matters, right? You're already up the creek, as it may be. But if you have a properly done contract, ending it properly is just as important. So the largest benefit, and we've talked about this already a few times, the largest benefit of having a fixed term contract is having the inherent notice period. If you give someone a year's fixed term contract, they've been given a year's working notice that it's going to be terminated. But that only works, again, if you have a specific end date in your contract, right? And that if you want it to end early, that you have a termination clause is enforceable. Important note: if you have an end date in your contract, and if I know every time I do a webinar, speaking event or something like this, I always get a question similar to this. What happens if we have an end date of, say, October 1st, but the weather's still beautiful and we want to keep going and we need our workers? So you just continue on with the contract. You need to know that the day after, if the end date was October 1st and they come to work on October 2nd, it's no longer a fixed term contract. It is now a permanent contract. All that means is you owe termination pay, and you could owe common law. The idea of you not having to pay anything or give any working notice at the end of the contract no longer exists. If you let it go even one day, it now becomes a permanent contract. Okay, so there's always a question about that. If you want to get by it, just so you know, I've alluded to it a few times. In all of our fixed term contracts, and any fixed term contract that you should have the end date, and then you should have another line that says, we reserve the right to extend this contract upon mutual accord of both parties. Basically saying that as long as you do it before the end date, if you do it after the end date, it doesn't matter if you extend it at mutual accord, it's permanent anyways. So as long as you go, if the end date is October 1st, you go to your employee before October 1st and say, listen, our golf season is going to last at least another 2 weeks long. We're going to extend your end date two more weeks. Are you okay with that? Get a little amendment to the fixed contract. It's 2 lines, signature, done. Now you have a fixed term contract that's been extended another 2 weeks. And if you have to extend it again, so be it. It's a little bit of hassle, if you will. But when you think about the alternative, it's 2 minutes of your time, right? So that's how you get around it. Ending a contract early. Now, we've already talked, unlike permanent contract, I always get ahead of myself with these things. I can't help it. And unlike permanent contracts, if you end a temporary contract early, a fixed term contract, you have to pay out the entire duration of the contract. And in the spirit of time, knowing that I talked about this a little bit earlier, I'm not going to belabor it, just to say that the only protection you have against ending a fixed term contract early is a really good termination clause. One of the kickbacks we get from our seasonal workers, and I know one of you, at least one of you, is on the call, because there's tens or hundreds of you out there that say the exact same thing. Your contract that you provided us is way too long. And I go, I get it. We can do a seasonal contract for you that is shorter than our typical permanent employment contract. Not a problem. We will not change the termination part of it, though. You have to know that. If you're asking us to do you a seasonal contract where it's shorter, absolutely. We could take that 7-page contract and turn it into 4, but there's still going to be that 3/4 of the pages that is about termination clauses, because it protects you, and that's our job, right? We don't want to be seeing you paying out 3-4 months for an employee because they, weren't fitting the bill and you never had a proper termination clause in there. So termination clauses across Canada have been in flux for the past decade. Again, just because you have a termination clause in there doesn't mean that it's good, right? So that's what we're here for. We're going to review it for you. We're going to make sure you're in a good spot, right? And if it's bad, we'll give you the one that we've already developed. It's been lawyer reviewed. It's good to go. So, but not only that, it must be executed properly. So this is a great case of Thomas versus Cardell Homes Limited. This is a case where they had someone on a 2-year contract, right? And then they had a clause built into his contract that should he be terminated earlier, he'd be given 12 months pay. So it's kind of inclusive, noting the kind of position they were in and so on. So what ended up happening is that a month before his contract ended, they decided to say, okay, we're going to end your contract on its end date. Great, no problem. But then they told him go home. So they didn't let him work the last month of his contract. They're going to pay him for it, but they didn't let him work the last month of his contract. He argued that he was constructively dismissed, and he won. So even though they were ready to set, and they just had to let him work for another month, even though they were ready and set to let this guy work for another month, and then he would be off and they would have owed him nothing, they ended up having to pay him 12 months. So it's not only good enough that you have a termination agreement, a termination clause, it must be actually reviewed to be enforceable, and then you have to use it properly. And this is what I went to the very beginning, why permanent contracts. A lot of people are moving to permanent contracts because there's so many nuances about fixed term contracts that most of you, thank goodness, have not, like I talk to our golf course owners all the time, and our other seasonal employers as well. They typically have not had to go through this, but more and more, and again, the lovely conversation I had with the golf course owner yesterday, she said over the last few years, it's been unbelievable. She goes, these kids come in and they know exactly what they're talking about, and it's frustrating. And it's like, and then a lot of it is inner reflective, that these are things that you haven't really had to follow or examine in the past, but now and again, that's okay. We're here to help. And termination versus layoff. This is another frustrating thing for me. And when I say it's frustrating thing for me, because I'm empathetic to my clients, because this is a term that is used the wrong way. It's accepted even by Service Canada, but for legal ramifications, layoffs and terminations are completely different things. A termination means you are letting somebody go. You are separating employment. Doesn't mean you can't hire them again next season. Doesn't mean you can't hire them again for the next construction project or next Christmas, whatever it is that the seasonal work you do, but you're letting them go. You're severing ties, you're ending it. A layoff means they're still your employee. You're just on a break. Right? They don't get anything that an employee gets, but they're on a break. Here's the problem, is that a lot of these seasonal employers will lay off an employee knowing that they can get AI that way. And they could get AI if they're terminated, by the way. As long as they're off work through no fault of their own, they get EI. And it doesn't matter whether it's termination without cause or layoff. So just to get that misnomer out of the way. But if you lay off an employee, let's say, again, golf course, I'm going to go back there. Let's say you're a golf course and you lay off an employee, you say, I have every intention to bring them back next year, but the period of the season, that is the off season, lasts longer than the allowable layoff period, right? So in most provinces, it's 13 weeks, certainly in BC and Ontario, the two of the biggest of the three. And I think in Alberta, I want to say it's 13, but anyways, most jurisdictions are around the 13-week mark. So if you're off season, if you laid an employee off and your off season goes longer than 13 weeks, they're automatically terminated. They're terminated. They can come to you that day, 13 days plus 1, and say, you owe me termination pay. Stuff, things that you thought you did everything right. You ended, you had the end date, you had the termination clause, you ended on the end date, you laid off the employee. 13 weeks comes, you get a call, you owe me termination pay. You have to pay it. That's why, like, layoffs are great. Layoffs are fine, provided you can get them back within the period of time, which is the layoff period. If you can't do that, you're shooting yourself in the foot potentially. Okay, so just so you're aware of that, there's a big difference between, I don't know what happened there. There is a difference between, did my slideshow go backwards? There's a difference between layoffs and terminations. It's a big misnomer that they're the same thing. A lot of people in the States believe that you actually call terminations layoffs, which is frustrating. But a layoff is temporary. They're still your employee. They're just on hold. And if you don't bring them back by the end of the layoff period, they're automatically terminated. Even if you gave them new employment, you would still technically owe them termination pay if they complained. Okay, and then the last slide before we hit to the questions, and I'll try and make this quick because we were close to our time anyways, but this is super important. This is the one issue where all of my seasonal employers, all of our seasonal employers, begging your pardon, because I think most of my team is here watching, which is great. But all of our seasonal employers ask these same questions all the time. Concurrent employment. When does all these seasonal contracts actually end up, or how does all these seasonal contracts end up to become a permanent contract, even though you're keep on doing these fixed term contracts, right? So the fact of the matter is, whenever you start to put stuff on top of one another, what looks like a fixed term contract or looks like a temporary contract, 3 or 4 of those temporary contracts in a row, and then a court or a third party starts to look at it and say, hey, that's no longer a seasonal contract. I know you're doing it for the purposes of avoiding, the termination obligations under the Employment Standards Act and the Employment Standards Code as it is applicable to you. But in fact, in reality, you've had these people back here for 20 seasons in a row. There is an expectation by both sides that they're going to get called back to work. So when there's that expectation that's set in, and they don't look for other jobs because they have an expectation that they're going to be called back to your workplace the next season, that is highly likely that they're going to be considered concurrent. And when you consider that there's people that have been doing this for 15, 20 seasons in a row, you're talking about 15, anywhere from a year to 2 years of termination pay. So it's super important that, you be aware of what the courts look at, okay? So one of the things that's key in whether it's deemed to be concurrent employment or not is there's no application process. So when you continue to bring back the same workers year after year after year, but you didn't do an application process, you just simply, there was no posting, there was no anything. You just gave them a call and said, can, ready to come back on Monday? That is one of the things that is indicative a court will look at and say that is one of the factors that may contribute. None of these factors by themselves necessarily say that they are concurrent, the series of fixed term contracts, but certainly that's one of those things, right? The courts find importance, and ironically enough, this is something I always do research before my webinars that I do for you folks. I know my stuff, but I want to make sure that we give you the highest integrity of HR advice and knowledge. And this is one of the things I was not aware of. I knew it was a factor, but I did not realize the amount of case law there is out there where the court has cited that in each ROE year after year, the employer noted on the record of employment that they are returning next season. That's the essence of what we're talking about here. Expectation. If you have an expectation that the employee is going to return next year, and the employee has an expectation that they're going to be called back next year, the odds of that being concurrent is really high. And how better to prove that expectation? The employer wrote in the ROE that this employee will be back next year, right? So that's something to be mindful of. I didn't know it. There's probably more of you on this call that knew it more so than I did. The most common application of concurrent employment, though, even though that's the one in the top right corner, if you're looking at the screen the same way, even though that's the one that the courts use, the most common that has resulted in massive outcomes for employees is when the concurrent employment would be over a length of term. So we're talking 15, 20 years, what have you. At that point, it's hard to argue. It's really hard to argue an employer or a lawyer on behalf of the lawyer, or even an HR rep who represents all of you, right? It's hard for us to argue that your intention or expectation wasn't to bring them back after they've been there 15 years in a row. And if you have them there for 15 years in a row, and then you call them up 2 weeks before the season's supposed to start and say, we're not bringing you back, that they're going to sue you. And in this case, in the Levy versus Canwu, the guy got 12 months pay. He had been there for 15 years in a row. The employer just called him up a month before he was supposed to start and said, by the way, we're not bringing you back next season. He sued, arguing that the employment was concurrent, that there was an expectation that I would be called back. I had not searched for alternative employment. If they told me at the end of last season that they weren't going to call me back, I would have had the whole off season to look for alternative employment. They didn't do that. They waited till a month before. Now I have no employment. So they basically paid him a year and said, here's a year, go find alternative employment. These are the things you need to be aware of, right? Your employees receive promotions, pay raises, and or increased benefits over multiple seasons. This, again, with the lovely conversation I had with the golf course owner, this is one of the things that frustrated me, that after you have somebody there that's there for, a few years, especially when you have students, whether it be over the holiday season in a retail sector, or, or at a golf course or what have you, or landscaping as well, is if you have students that, they move to head of crew or something of that nature, or they move to like vice super or whatever it is that you would call them. You want to be able to give that promotion. You just have to be aware that by giving them promotions and raises over the years they're there, outside of COLA, like cost of living increase, by giving them promotions or arbitrary raises over the time they're there, over the course of their employment, there's a better chance that a judge will rule that that employment was concurrent. And finally, in order to try and protect yourself, and again, it's not it by itself, this wording does not protect you from any of the other things on the screen. It does mitigate your damage a little bit, especially for short-term relationships where you've had somebody hire for 3 or 4 years. When you put in your employment agreement that employees should have no expectations to continue to renew, if you did that, if you had that in your employment agreement, and then you did an application process every year, even if you knew in the back of your head that you were always going to hire them, and you certainly did not put it on the ROE that they're coming back, the chances of you not being done with in a seasonal employee being called permanent is much better for you. So those are the things you need to be aware of. Again, Kim said, I tried to talk a little bit slower this time, but I know I'm still quick. But Kim said this would be, taped or whatever you want, recorded, and sent out to all of you. Please, if you have the opportunity to show this to your teams, this slide in by itself is super important. I hope that in the brief time we had, that you were all able to get some value out of this. That's my dog. He's super cute. He has been very quiet and thankful. So yeah, thank you all for attending. I'm going to turn it back to Kim. Appreciate you all.
Awesome. Thanks so much, Darcy. That concurrent employment slide was a real eye opener for me. That was a little crazy. I didn't know a lot of that. Fantastic. And I love it when your dog makes noise. Has anyone heard that before? Oh.
It's a little bit different in a webinar. He's
another webinar. There you go.
Yeah, when you get it could be really noisy.
Hilarious. So love it. Quick reminder, all of our clients here, reach out to us, please, for the most up-to-date fixed term employment agreements. We do make changes whenever there's updates to case law and legislation, or whatever we can to keep you as protected as possible. I see there's a lot of questions coming in. Honestly, I mean, as always, it's no surprise. HR can really feel sometimes like, I think to all of us, like a never-ending game of, did I miss a rule? What am I doing wrong? Every organization we know has its own challenges. The risks of getting it wrong, we know, and probably you know as well, they can be really costly. And that's exactly why having the right kind of support matters. At HR Covered, our focus is simple. Basically, we're providing protecting your business. We save you money. We get you fast, affordable help when you need it. If you're not a client, like Darcy said, why not? Come on, talk to us. We're nice. We're great. We'll help you out. For existing clients too, please reach out whenever you need us. I know there's a lot of different things that can happen. The best part, I think, of our services is, even though we do have some set programs, we cover everything HR and health and safety. So even if you're a client and you don't think maybe we do full service recruitment, or, or you just had the Ministry of Labor come in and gave you orders, can we help with that? We absolutely can. There's so many different things that we can do. And we've got your back no matter what. So whether you're a client or not, we'd love to hear about the HR problems keeping you up at night. If you ever need guidance, or even if you just want to say hi or tell us how much you loved this webinar, just reach out to us, service@hrcovered.com. We're here. We're happy to help you. So let's jump into our first question. Darcy, do we have to provide seasonal workers with vacation time?
Yes. So, well, begging your pardon, sorry, no. I right out of the gate, I got my wires crossed. You have to provide them with vacation pay. So seasonal workers typically, now if a seasonal worker if it's a seasonal workers are typically per season, so it never goes more than a year. So if it was a fixed term contract that went more than a year, then yes, you might have to provide them vacation time. But strictly with seasonal workers, because they're employed with you for less than a year, you do not have to provide them with vacation time, but you still have to provide them with vacation pay. So, which is actually our team, our HR team here on our end, we had a question from a golf. Actually, I'm not even sure if it was a golf course or it might have been another seasonal industry, where they emailed in and said we've hired somebody 5 years in a row. Do we have to give them the 6% pay versus the 4% pay? And I point to that last slide where it talks about concurrent employment. And if they meet if they meet any of those criteria, those first four criteria that are on that slide, then yes, you would have to give them the 6% pay. So if you're not doing job postings, if you're putting on the ROE that they're coming back, if you're laying them off, not terminating them, all those different things, then they've been with you for 5 consecutive years, even though there's a break in employment, you owe them the 6% pay. But you do not owe them vacation time in any given year because they're never with you for a full year. And they have to be with you for a full year working to be able to use the vacation time they would have earned.
Okay, wonderful. I'm going to ask you a little follow-up to that one, because I know clients are always asking me this too. When you're paying vacation pay, and I know I always send this off to our wonderful advisors to answer, but if any of you in the room are wondering this too, when you're paying out vacation pay, are you responsible for tracking when they take vacation time or encouraging them to take it?
Yeah, if you're only paying out vacation pay, then, and if like in a seasonal circumstance, then you wouldn't have to worry about it because but otherwise, yes, you have to track vacation time. Because if you're one of those employers, and this kind of breaks away from seasonal, but it's incredibly applicable because some seasonal workers more work with 1 year, the seasons blend. When you are paying in every jurisdiction across Canada, you're required to track vacation time for non-exempt employees. So if you're not a manager, supervisor, exec, etc., you have to track their vacation time. They're entitled to 2 weeks vacation time. You are, as an employer, required to make them take it. This is one thing that most employers don't know, is that even like their employee might come to them and say, you know what, I'd rather just work 1 week and just pocket the other week of vacation. You're required to make them take it. They put that in the legislation for a reason, so employees get a break. So, and employers are, if they're not willing to take their vacation, you can let them carry it over, but you shouldn't. In reality, what you're supposed to do is say, give us your vacation time. If you don't give us your vacation time, we're going to book it for you. But yes, even if you're paying vacation pay and not coupling it with the vacation time they're taking, you're still required to track the vacation time.
Excellent. That's great to know. Thank you, Darcy. Okay, next question. We don't hire seasonal workers, but we do use fixed term contracts. Does everything you said in this webinar apply to us?
Yes, and it's worse. So yeah, the only reason there's any ambiguity about concurrent employment for seasonal employers is because there's a break in employment. When you're one of those, school boards do it all the time. Non-for-profits do it all the time. They will put people on 1-year contracts, then they get funding, or they decide on their numbers for the next year, and then they put them on another fixed year contract. The general rule of law, and it is a general rule of law, it's been established over the last couple of years in part because of COVID, because a lot of this type of employment has come out of COVID, the term contracts, because of the uncertainty. And I expect that this can remain to happen with what's happening between the United States and Canada with the trade war thing, is that after 3 years of fixed term contracts in a row, you're permanent. It doesn't matter that you have funding, or it doesn't matter that you're permanent after 3 consecutive contracts. So or 3 years of 3 consecutive contracts. So yeah, it's actually worse for you. There's no ambiguity for you about, whether or not it's concurrent or not. They're concurrent.
Oh, that's incredible. And good to know, I'm sure, for a lot of you out there too, that have had workers in that situation. Okay, regarding setting expectations, and I think this is referring back to when you're talking about setting up the expectations of how long their employment would be in their fixed term agreement. What if it refers to that having them follow other policies, kind of like their policy manual and that sort of thing, and including attendance in one of those policies?
Yeah, like that's fine. We had this conversation before in our employment agreement, the importance of the employment agreement. like policies themselves, if you want to make them a condition of employment, they need to be given to the employee at the time of signing or before. You can't say this is a condition of employment after they sign the employment agreement. You can write something, and we do this in our employment agreements, where we say that you will be provided with the policy manual within 2 weeks of you starting with us. You'll be provided 7 days to read and review the manual, at which point they will be considered a condition of employment. So you can say in the employment agreement that it will be given to you, and then it will be an expectation of employment that you read, review, and understand them, and then you sign a waiver to, or sign an acknowledgement that you did so. But if you don't give them the policies on attendance, for example, or don't specifically note something in the employment agreement about attendance, you can't make that a condition of employment. So you might be able to terminate them, but it's not going to be for cause.
Okay. Yeah, that's good. Good question. Great answer. Love it. All right, next one. Do we have to train our seasonal workers on health and safety courses before they start work?
Yes. Now, this is actually our VP of sales, I think, Dave. He asked something similar today in one of our group chats because a client had a similar question. And there is an allowance. Whenever you hire someone, there is an allowance that you can, within the first little while, a reasonable period of time is what most acts or codes say. You must train them within a reasonable period of time. With seasonal workers, it's a little bit different. You are not going to put somebody on a grass cutter machine, or you're not going to put somebody in a construction site. You're not going to put somebody in a shipping receiving role during Christmas time unless they've been trained on to do it either before they start or in the first few days they start. In other words, their first 2 days should be onboarding, training, et cetera, et cetera. Especially with retail workers who hire a lot of young people, golf courses who hire a lot of young people during the summer, and then just people in general that hire young people in the summer. It is critical that before they start doing any work, that they're trained. The Ministry of Labor or Labor Board, depending on your jurisdiction, will bury you, because the young workers are considered vulnerable workers, and there's very strict legislation and a zero tolerance approach to enforcement when it comes to new work. You do not put somebody on the work site until they've been trained if they're a young worker, period. It happens all the time, but you do so at your own peril. And there's no excuse that you can offer to a Ministry of Labor inspector when they show up their door. They're going to listen to you. And I've worked with the ministry for a lot of years. Trust me on this one.
Yeah. And you always think of all those clumsy people too, even if they're not on a lawnmower. What if they trip and fall over a cord? What do you do then?
Me. Can't train.
It happens.
You can't train my kind of not skilled at that kind of stuff.
There you go. Okay, next question. Hearing all of this, I am wondering, is there a benefit to using permanent employment agreements for seasonal workers?
Yeah, and it's a two-edged sword, right? If you're one of those industries that your layoff period is going to be less than the period of time in which it would be considered termination, so again, typically 13 weeks, absolutely. I don't understand the reason you wouldn't use a permanent agreement, knowing that you're under so much liability of making sure not only that you have the termination clause, but that your termination clause is always up to date, which is hard to do. It's our clients sometimes gets frustrated with us because we're emailing them and saying, hey, by the way, there's been another change to the termination, and we're being proactive and trying to protect them, but it's frustrating for employers. It is, and I understand. So if you have an opportunity where you could take that off your hands, and the worst case scenario is you'd have to pay a few extra weeks instead of months because your termination clause wasn't there or was void, then yeah, I totally recommend it. Now, if you're one of those companies where your season is going to last, your off season, beg your pardon, is going to last longer than 13 to 15 weeks, sure, there's a merit to using a permanent contract, especially for your longer term employees, because at any point, especially if you already know that they're likely, based on the factors that I kind of gave you in that last slide, you already know they're likely going to be deemed, permanent anyways, you might as well just put them in a permanent contract. It's easier for you because you have a termination clause that pays up to the ESA, right? So ESA or ESC, beg your pardon. So yeah, but if it's a shorter term employee, if your season is going to be longer or substantially longer than 13 weeks potentially, fixed term contracts still have their merit. You just have to be really careful about how you use them.
Yeah, and I can see there's a couple questions coming in as you're saying that. So kind of a follow-up to this one as well. If they've already signed a fixed term agreement, can we switch them over? Is it too late? Can we switch them over to a permanent one?
Yeah, you can ask them. If they, whenever you're switching one person into another, because you have to be careful with this, because it's not an issue of you terminating the fixed term contract for the reasons we mentioned in there, and then putting them in a permanent, you would need like a mutual accord and things of that nature. And then you would also have to provide consideration. So what consideration is anything of value to the employee? So if you went to the employee and say, listen, we'd like to make you a permanent employee rather than a fixed term employee. So we're just going to make it, you're basically giving them a new contract. It's an amendment. You're carrying over the contract. You're not really ending their last one. You're just putting them into a new situation. And then you give them a consideration. Could be a half a day off. It could be a box of cornflakes. It's anything of value to them. It doesn't, the courts don't care. As long as the employee is happy with what you're giving them, then it becomes a legally binding agreement when both parties are getting something. Obviously, you're recommending the permanent contract, so you're getting something out of that. The employee needs, even if they said, yeah, I'm all about it, if you don't give them consideration, then it's not a legally binding contract. You have to give them something of value. Easiest way to do it is give them like a $5 gift card to Starbucks or something like that. And if the employee's happy with that, great. Everybody likes the easier.
Perfect. Great. No, that's amazing. Okay, next question. Can we fire an employee who gets injured or sick and can't work for most of the season?
No. Sorry. Did you want me to expand? No, that's whether it be a permanent. I know whether it be a permanent or a seasonal employee, you can't. You just like when they're if they're like. I get the nature of the question now that I'm reflecting on it. Like if they can't work for the most of the season or all of the season, then they're no good to you because we just let them go and let somebody else go. You just put them on a medical leave of absence and go and hire somebody else. That's all you do. When the end of their contract comes up, so if their contract was to end again, I use the example of October 1st. If they were still hurt when October 1st comes by, then their contract ended. Your obligation ends with that. Do you know what I mean? Unless you had short-term disability insurance or something like that. So it's like, yeah, if you were to terminate them, you could get, the thing you would be guarding against is a claim of discrimination based on status of disability. And you would almost certainly lose because there's no reason to terminate the employee. They could just be put on a medical leave of absence and collect DI.
Yeah, for sure. That makes sense. Okay, next question. We are a golf course and we have issues with employees trying to fit in their breaks when they would like them rather than when it's most practical for the club. For example, a worker who's cutting grass on the far side of the course and drives into the clubhouse to take their break because it's their break time.
Yes. This is a question.
Yeah. I think like, how do we control those break times?
Yeah.
Can we control them?
I actually wrote the question for the client. So because we were having this great conversation and she goes, you know what? I bet you all of my, my peers and my colleagues would like to know these kind of questions because of these things we go through. I go, you know what? I'll put them in the Q&A. We have a whole bunch of questions that have already been submitted. I'll put them in there for you. And then you can watch the recording or what have you. But it's a great question because we've had a few of our clients ask us this, whether it be like even in construction or retail, it's like, okay, like it's just, we got to walk up and get away and walk up. And we've had it we get this in unionized sector all the time because the unions want their employees to take their work breaks exactly when they're supposed to, right? It's kind of like, it's almost like a work to rule thing. You have flexibility as long as the general rule in almost every jurisdiction is if it's the meal break, the 30-minute break that you have to give them, where they're free to do whatever they want. So if they don't want to be like eating on their grass cutter or whatever it is, they don't have to be there. If they want to come into the clubhouse, they can be there. But you have flexibility. You don't have to assign them a break time. They just need to have a break within 5 hours of employment. So if you call them up, if they're near hole 1, which is near the clubhouse, for example, and like they're 3 hours into their shift, yell out to them or get on the walkie and say, listen, you're on hole 1, let's have your break now. You have the right to dictate. The worst thing you can do for employees in an environment like that, especially in like most seasonal environments, kind of hectic. Do you know what I mean? And they're so busy because that's why they're seasonal. Everybody needs them right there and then. You'd be unwise to leave yourself with no flexibility by starting to assign. There's certain times when it works, but starting to assign people breaks. Just say when, next time you're around in hole 1, anytime after this time and before this time, make sure you come in and take your half-hour break. The second half of that conversation was that they gave a 30-minute break, which is what they're legally required to. They also gave another 15-minute break. So for most jurisdictions, you're only required to give a 30-minute break. You're not required to give anything else. So the 15-minute break doesn't fall under the same rules that a meal break does. When a meal break, they can do whatever they want. If they want to leave the site, they're allowed to leave the site. If they're on call, you have to pay them, right? So if you're paying them, then you can do that. That's fine. But in those 15-minute breaks, that's just a break in service. if you say, listen, if you want to take a 15-minute break and sit under a tree somewhere on hole 7, which is the farthest hole from the clubhouse, knock yourself out, but you're not coming into the clubhouse for that. You could sit out there and take your 15-minute break. That's, so there's a difference between what you can do with that 30-minute break where they could do whatever they want if they're unpaid, and that 15-minute break where you're paying them for that 15-minute break. So you have control over them, and you could tell them, sit out there under the sun and chill out for 15 minutes and then start work again.
Yeah.
That makes sense. Yeah.
Those are always my favorite type of questions. And this is why I always think it's great to be able to ask the advisors directly, because there's always so many little things that it's like, oh, we don't want them here, we want them there. And at this time, fantastic. Okay, so this one, also a golf course. They're hesitant to use the 90-day probation period effectively. Any tips or concerns that you can provide? Is there a concern about terminating an employee when they're rarely available?
Yeah, that was asked by the same person, and it's a good question. The reason it's a good question is because if you don't have the 90-day probation period and it's well-written language in your employment agreement, and you terminate within that 90, the employee, especially young students, young workers, right, considered vulnerable workers, it's not inherent, no matter what we think as owners, HR people, what have you, it's not inherent that the employee would know that they can be terminated within 90 days without any working notice, without any pay, et cetera, et cetera, et cetera. It's super important that if you want to use a probation period in a seasonal contract or any fixed term contract for that matter, that you have clear and good written language around what the probationary period is and what happens if they terminate you within that probationary period. Second part of that question was, I know with this particular golf course owner, this person just stopped showing for work. And this is something we see all the time. Couple weeks in, 3 weeks into a seasonal job, young workers that got a couple paychecks in their pocket, see ya. You know what I mean? They'll show up when they want to. You know what I mean? All of a sudden they become unreliable. As long as there's nothing around religion, as long as there's like nothing about like holidays, like working on a Sunday, as long as there's nothing around medical issues, then if somebody starts to be unreliable and they're within that 90-day probationary period and you have a good clause in your contract, get rid of them. Like, I know in all seasonal industries, attendance is far more important than even in permanent situations, because in permanent situations, there's usually other permanent employees that can back up. But seasonal workers are there for a purpose. It's in a busy part of the season or the only season for those employers. They need them there. So if somebody becomes unreliable and there's not any issues around religion, like they're missing for religious holidays, missing because they go to churches on Sunday, or there's any medical issues, there's no reason why you can't use your clause.
Okay, perfect, great. And this one's along the same lines, but a little bit different. I'm assuming that it's maybe bordering on the concurrent employment. They have an employee that's invited to return, but it turns out that their availability has changed. Do they have to rehire them, or what are the drawbacks there?
If they made a job offer, like a formal job offer, then you're stuck with the job offer because you should have asked about their availability before the job offer. Now, if they made you aware of that at the time of job offer, then that's actually considered a counter in my point of view. So once somebody makes a counter offer, if no one didn't know this, it's kind of a caveat, but most employers don't know this. So it's a good tidbit of knowledge. When you make a job offer to somebody, right? So when you make a job offer, you've bound yourself, which is why I'm not a big fan of job offers. You give them the employment contract and say, this is what it is. They accept it, they don't. Job offers have no purpose in today's world. They're useless documents. They only bind the employer. Off my soapbox. But when you make a job offer to someone and that other person comes back and gives you a counter, whether it be changed availability, can I have $2 more an hour, what have you, the original job offer is void. Once they counter, the original job offer is void. So you have every right just to say, you know what? No, the original job offer is void by you making a counter. See ya. So if they made a job offer and that person said our availability changed and said, well, we can't give you the job, you made the job offer void because we made it under these conditions, then yeah, they don't have to hire them back.
Okay, perfect. Next question, do we have to pay them for training?
Yes.
Yes, you do. I always tell people too, even if you're the owner, do the training. Everyone's got to do it, right? All right, and I think we're getting right near time here. I'm going to take one more question. Do seasonal workers count towards employee counts for requirements such as health and safety committees?
Yeah, that was actually a question that our team brought up earlier this month too, with all these questions we're getting with seasonal employers. Yes and no. It depends on the jurisdiction. Like for example, in Ontario, and Lynn, who I think is on this call, she did the math work on this one, and it was great. Thank you. Lynn's our advisory manager, by the way. Most of you spoken to her, but it's plug, plug, plug. But she found out like if an employee is with you, the status, if they've been with you for 3 months or more, then they're considered an employee for the purpose of employee count. So most seasonal industries that, in most jurisdictions, there's something very similar to that. So you're going to find that, yeah, in most industries, for most jurisdictions, they're going to count towards the employee count for things like joint health and safety committee and other things. When it comes to accessibility legislation, whether it be BC or Ontario specific, because those are the two places that have, federal too, I guess. Federal, those are the three places that have the strongest kind of accessibility requirements. If they show up for work for even a day, they count towards your employee count. So that's super important. Like if you had somebody show up, if you had casual workers who showed up to work for even one day, they count towards your employee count for accessibility legislation requirements.
Okay, that's great to know. Thank you. Now, I know, as I feel like there always is, there are questions still here. We want to answer them all. Even if you're not a client, please email in. It's service@hrcovered.com. We want to answer these for you, get you the answers that you need. Again, I know I've said it before, but every situation's a little bit different, and there's always those little nuances where, maybe Darcy answered part of your question, but your situation's just a little different. Reach out, because it can definitely impact the answer, and what that's going to mean specifically for you. And I'm just going to put a little plug in for our next webinar. It is coming up April the 10th at 2:00 Eastern. It's going to be with HRC Law, Tom and Lubisa. If you haven't seen them before, they're both absolutely amazing, very knowledgeable. They're going to be able to go through everything from last year. So 2024, a year in review for employment law. There's going to be lots of great stuff on there. So if you can, put it in your calendar, make a point of being there. And thank you so much, everyone, for joining. I know it's always time out of your day, but time very well spent, I'm sure. We love seeing you here. We love having you here. Again, please reach out, send us your questions, say hi, whatever. Just reach out to us. We're service@hrcovered.com. Enjoy the rest of your day.
Take care, everyone.